Now we'll talk about documentation of informed consent and informed decision making. We'll use examples pertaining to end-of-life care decision making, but documentation of informed consent, the basics apply to any form of consent, whether it's life-prolonging measures, discontinuation, or institution of resuscitation or resuscitative measures, sending someone home, or doing surgery for more minor situations. It would be the same principle. Anything that you will do or not do that would expose the person to significant harm or risk of harm usually would require a documentation of informed decision making and informed consent. So first of all, who needs to get the informed consent and who needs to document the informed consent? Ideally, who needs to fill out the informed consent form and or document the informed consent and informed decision making. It would be the person directly responsible for the procedure or the act that is going to be done or not done, whether it's a consent not to proceed or a consent to proceed with CPR or consent not to proceed with CPR, consent to intubate and attach to a ventilator or consent not to intubate or attach to a ventilator, consent to continue medical care inside the hospital, or informed decision to refuse the advice of the doctors and refuse further hospitalization, consent to surgery or not. So those are the big decisions. Usually the things that would require informed consents would be those that would expose the patient to any significant risk of harm, material risk, significant risk of harm. It would be any action or inaction that would expose the patient to significant risk or material risk. Usually the risk that we're talking about or the harm that we're talking about would be significant. For example, death, getting paralyzed, losing an arm, losing a leg, loss of an organ, loss of a function of an organ, significant infections, significant loss of function. So those are the things that you usually get consents for. What it means is the patient or the family member, if the patient is incompetent already, needs to hear what those risks are and needs to decide whether they want the action or inaction that would expose them to this material or significant risk. Material risk would be what lawyers would usually say, but it would be a lot easier for us to just say significant risk, right? Or severe risk to harm or death. Okay, so that would be the person who will order the action or inaction, or the person who will do the action or not do the action. Why? Because he's the best person to explain things well to the patient, right? So the person performing the trach, if the patient has been on prolonged ventilator with an ET tube and they called up a surgeon to insert a trach, the best person to sit down and get the consent for the insertion of a trach would be the person inserting the trach, because obviously he's the expert in such things. So the patient would ask for particular details like what are the risks involved. He would be the best person to tell the patient and or the family what the risks are. Also, he would be the one who would benefit the most with a well-documented informed consent. Why? Because just in case a complaint or a suit is filed, he's the one who would need that documentation, who would need that consent form, that well-documented consent documentation. Not the nurse or not the trainee who's watching him do it. It would be him, or not the hospice doctor who's taking care of the patient and doing something else, or not the nephrologist, but the one who's going to insert the trach. In the same way, the one who's going to give the chemotherapy or not give the chemotherapy should be the one obtaining the consent for such procedure. Or radiotherapy, that would be the radiation oncologist, right? So that's how it works. The primary service was going to talk to the patient and discharge the patient home, or the one taking care of the patient primarily in the hospital would be the main service who is in charge of handling a home against medical advice case, because they're their primary service. That's pretty much how it works. So now what about the other people? Like, for example, the nurse or the clerk or the intern watching the consultant or the senior resident get the consent. Well, you're probably a witness, and you might even be asked to sign as witness on the consent form or on the consent documentation. So what is a witness? A witness is precisely that. You're standing there, you're witnessing the entire thing. You're just watching, you're witnessing, you're not doing anything else, okay? Meaning, if you're not there, then don't sign yourself as witness because you're not there. For example, it becomes a court case and they saw your name there, you signed your name there, and then they asked you, what did you see? What did you hear? And then you tell everyone, well, I didn't hear or see anything because I wasn't there. They got the consent and then brought the paper to me and asked me to sign it. Even if you got the paper and went back to the patient and asked them, did you really sign this? Or did you really talk about this? And the patient said yes, and you signed, still, you're not a witness. You cannot answer anything, right? If they ask you, okay, witness, what happened? How was it done? Are the stuff written here exactly the way it was done? What did you hear? What was happening? You can't tell because you weren't there. Okay, so you're not a witness. Don't sign. So a witness would be the one standing there, witnessing the entire thing. Now, if the consultant or the senior resident got the consent because they're the ones who's going to order whatever that consent is for, because they're the ones in charge of the action or inaction or the surgery, and then they told the patient, okay, think about it, these are the informations. They gave them all the information, and then they said, okay, I'll give you time to think about it, and then they left, and then you're left there looking at the patient, and then the patient asks you for more information, and you gave them more information, especially if the information that you gave contributes significantly to their decision, then you're not a witness anymore. You become part of the information giving in the consent process, right? So you're not a witness. Why? Because aside from the doctor who just left, who gave them information, unfortunately he left out certain things, and he didn't stay to ask the patient or the family if they have any more questions. So he just left, and the family asked you, then you gave the information that proved to be very significant in their decision. You become part of the consent process. You're not just a witness. Okay. Now, the worst case scenario is there was a suit filed regarding the obtaining of the consent. The family and or the patient said it was fraudulent. It wasn't complete information, or it was wrong information, and they pointed to the information that you gave. Then you're in trouble, right? So if you're just there to be a witness, don't add on to the information that the doctor is going to do the action or inaction will give, okay? Now you're allowed, if you're the nurse or the junior resident or the clerk, you're allowed to reinforce what was said, or you're allowed to repeat what was said. So bottom line, a witness is just a witness, okay? So if you do something else that a witness doesn't normally do, then you're not a witness anymore. You're something else, right? So if you give additional information and that information proved significant, and they were alleging that information that you gave was fraudulent, then you're in trouble, right? So now what you can do is you can try to reinforce or repeat or add universally accepted explanations to what was said, okay? Of course, obviously the guy who was your senior, or this consultant, or the senior resident, or the one you're watching, the doctor who was sitting down explaining things to the patient, giving the information, should have made sure that they understand things well. But things do happen, and sometimes the family is just trying to absorb things, and then the doctor leaves for the family to think about things, and then while they're thinking about things, they realize there are certain things they're not so sure about. And you're standing there, or you're the nurse, or you're the clerk, or the intern, or the junior trainee, or the junior resident, and they asked you. Now, you can repeat what was said. You can reinforce what was said. You can give basic universal explanations to what was said. Something like if they asked you what a dialysis is. Hopefully they don't do that, because if you're the one getting the consent and you said things about dialysis, and all the while the family didn't understand what dialysis is, that's a really bad way of getting consent. But anyway, they asked you for some clarification, and you gave a really basic explanation or clarification, and then that's okay. It wasn't a significant information that's different from what was already given, so that's fine. Now again, if a complaint or a lawsuit was filed, and they got you, the doctor who got the consent, together with the witnesses, and asked each one of you what was said. Did you really explain things to them? Was this particular risk discussed? Then it would be nice if you have a documentation of everything that happened. That would reinforce what you're saying, right? That would support what you're saying. And that's one of the main reasons why you want to document things well. Now, if you just use the form, the generic forms used, the reason why the form is generic is because there are several actions or inactions that the form is used for. And so it's not specific, like a particular action or inaction would result in different risks. So it just says there the risks were discussed. The patient understand the risks, or the family understand the risk involved, or information was given about the risk and benefit. I mean, just general terms. Now, if that paper was presented in court or during an investigation, then that doesn't support whatever you're saying because it doesn't contain anything, right? So the main advice is if you're going to do or not do something and that particular action or inaction concerns a very significant material risk, then don't just use the generic form. Write everything down or document everything in a separate piece of paper and do the form, because that's usually that's the procedure of the hospital, but at the same time do an additional documentation of what exactly happened. The form just says, I discussed all the risks, but it doesn't say what risks were discussed and what risks were not discussed. So write down or document what you just said, all the risks that you just said, right? And all the important information was given. That's what the form says. Now, in your own documentation, in your additional documentation, write the information that was given, especially the most significant ones that might influence the patient or the family's decision, right? Now, usually that would be a list or summary of risks discussed, information discussed. And then what else does it contain? Well, there must be a statement saying that all the patient or the family, if the patient is incompetent, all their questions were answered, right? You have to put it down. You don't just say, well, we talked to them. Obviously, they asked questions and we answered. No, it's not obvious. You put it down. They asked these questions and I answered these questions. If it's a significant question, you write down what you answered, right? Now, sometimes if you feel like, it's very straightforward, then just write 1 or 2 sentences saying that you asked them for if they have any questions and you answer their questions. Of course, if you feel like the situation or the decision is very risky, write down the details about the question and your answer, right? And finally, another important thing that the documentation must contain would be the patient or the family's response. Like you gave the information, you answered their questions, and then what was their response? It can be something as simple as 1 or 2 sentences saying that they understood the information, and when asked if they have any more questions, they said no. So that's one way of doing it. Or you can add a little bit more detail than that. So it could be simple statements stating that the patient and or the family understood, they acknowledged, or they expressed understanding. The patient and the family expressed that they understood well what you just said, or the information that you just gave, and that would be enough. Now, again, you can add more details if you feel like those details would clearly depict them as a family or a patient who completely understood what you just said, right? And then that's pretty much it. So a summary of information, risks, etc., answered all their questions, and the response of the family. They understood, they acknowledged. Okay. Now, the other thing that would influence the content of the informed consent would be what the law requires. Now, again, before you get the informed consent about doing an action or not doing an action, make sure that whatever it is, it's perfectly legal in your country. Getting an informed consent on something that's illegal will still get you in trouble, right? So, for example, the assisted suicide or assisted death is illegal in many countries. So even if there's self-determination and the patient understood that if you do this, they'll die and they want it, that's still illegal. So autonomy is not superior to the law. So make sure about that. Like if you're going to extubate someone who's not yet dead or is brain dead, then make sure there's a law that allows you to extubate someone who's brain dead, or make sure that there's a law, or even worse would be someone who's not brain dead, someone who's less than brain dead, someone who's much more conscious than brain dead. Now make sure that there's a law that allows you to do something or not do something that would expose that particular person to significant material risk, like death or significant harm. Okay, so make sure there's a law. Now, usually when you have laws like these, laws on extubation of people who are still conscious or who are vegetative or who are brain dead, then usually the law contains specific requirements. Like, you can only do this if the situation is this, this, and this, and this. And in doing so, you have to get the consent and cover these things, 1, 2, 3, and 4. So the law itself, or the policies or the rules coming out of the law, would also require you to do things that you might need to document, that you would probably need to document just to prove that you followed the law. Okay, so now if a complaint was filed and there's an investigation and or a lawsuit is filed, you have a better case if whatever you're saying is supported by your documentation, right? Because it would support what you'll say. Obviously, you'll probably try to defend yourself and say, well, I did everything right. This is what I said. I actually said that. Unfortunately, it happened. So, or they understood and it happened, but I told them about it, or I discussed the risks, and certain risks cannot be removed, and they agreed, and it happened, but they agreed. Of course, they'll question it. Really, did you say it that way? Did you clearly explain it? And if you say yes, it would be nicer if you said yes, and then you bring out the documentation, and the documentation shows that you actually did it. And so that's how good documentation can be useful to you in your defense, right? Now, of course, the family can still do certain things, like they can say that, it was fraudulent. Okay, they can still say that, like, that was written down, but it actually didn't happen. So they didn't say it, so it was fraudulent. Now, that consent that's well documented is valid unless the family or the patient, if the patient is still competent, it would be the patient who's deciding for himself or herself, as the law requires you, unless they argue that the information sharing and the informed consent was obtained and done in bad faith, was fraudulent, wrong information was given, biased information was given. They were forced into a decision based on incomplete presentation of information or biased presentation of information. Or they can say that the doctors only gave information that would make them agree or not agree to the procedure. They didn't give all the information that they need, or the explanations were biased. So that's fraudulent. It was done in bad faith. Okay, they can still say that. Now, a consent form that is clearly problematic would be a form that is written in English, and it was given to a patient who does not completely understand English. So that would be a really problematic situation. Or it was filled with so many technical terms that a layperson with the patient's level of education won't be able to understand. Might as well not use the form. Just sit down, use language that the patient can use, and write it down yourself. I mean, that's a worthless form if they cannot understand most of it, right? It's not even going to support you. It's going to get you into more trouble. Why are you using a form that they cannot understand, right? So that's, might as well not use it, right?